Okay, right. Hello, everybody. For those of you who weren't just at the stage where Derek and I were welcoming everybody and saying hello, I'm Linda Gibbs. I'm the Dean of the ICCA, and I'm delighted to host this session this morning on the commercial bar, practice at the commercial bar. And what a time it is to be considering a career at the commercial bar. It has its own specialist bar association, and they describe themselves as practicing nationally and internationally in a wide range of litigation, arbitration and transactional work, often being called to appear in foreign courts. They have extensive experience of representing clients in high-value commercial disputes across a range of sectors, including banking, insurance, shipping, commodities and international trade. We are entering uncharted territory at this point in history, with almost certainly multi-million pound transactions and agreements for vaccines, and negotiating trade agreements as a nation which is no longer part of the European Union. According to the government website, there are 41 days for everything to change. Now, commercial law was not my area of practice, and I'm leaving it to the experts who've very generously given up their time today to join us. And I'd like to first of all introduce you to Andrew Hockhauser, QC. He's our wonderful Vice Chair for SBAs, who is leaving us shortly to take up his position as Treasurer at Middle Temple, and we will miss him enormously. Andrew.
Well, good morning, everybody. I hope that my telephone is not going to go off in the middle of this, and I will be able to do this session with you uninterrupted. Unlike the other speakers, I did not go straight into commercial practice. I did my first 6 months in an employment law set, and then I did my second in a set which did general civil litigation. Now, unfortunately, I was not taken on in my second 6 months set, and I was in good company. There were four pupils that were competing for one place, and unfortunately, I was turned down together with two people that you may well know. One is the current Chancellor of the High Court, Sir Geoffrey Voss, shortly to become the Master of the Rolls next year. And the other is Baroness Scotland, who is currently the Secretary General for the Commonwealth. So, as I say, I was in good company, but it took a while for me to find a tenancy. And I went to a set that did all sorts of practice: crime, civil work, and family. It was a general practice, the likes of which are very rare these days. And it was a question of how brief will travel. I shocked the clerks by saying that I was not interested in doing criminal work, and I focused on all manner of civil work, going to county courts throughout the country, employment tribunals, and the like. After 5 years, I was offered a tenancy in a more prestigious set, which did chancery work and civil and commercial work, and my practice became more commercially orientated, although I did do a lot of employment work. During my period there, I was instructed on my first really big case. It was an international asset tracing claim, and I had not one but two leaders, which for me was an unknown experience. The case lasted no less than 7 years, and I traveled around the world, and the case was listed for 7 months in the commercial court for trial, and it settled just before the action began. As a result of that case, I was invited by one of the leaders, Ian Hunter QC, to apply to join what was then 4 Essex Court, now known as Essex Court Chambers. And I was offered a tenancy in the beginning of November of 1991. So I have just celebrated my 29th anniversary there. When I arrived, my practice was very different for the other members of Chambers, and it has remained different. I have never done a reinsurance or a shipping case. My focus has been principally on corporate disputes and commercial contracts, principally concerned with the City of London and coupled with an employment element. It consists of interim injunctions, dealing with team moves, breach of warranty claims on sales of companies, enforcing restrictive covenants after the termination of employment or resisting them, dealing with bankers' bonuses claims, whistleblowing and discrimination cases. I appear in the Chancery Division, the Commercial Court, the Queen's Bench Division, the Employment Tribunal and the Appellate Courts, including the EAT. But my real focus is on trial work, and I really enjoy trials, planning a strategy and cross-examining witnesses. In 2004, I became a civil recorder, and most of my work was done at the Central London County Court. Since 2013, I've been a Deputy High Court judge, and I now sit in the Chancery Division, the Queen's Bench, and the London Circuit Commercial Court. And from that perspective, it gives me a great insight into advocacy, what is effective and what isn't. In the time available to me, I'd like to make 2 points, if I may. One, it is very competitive. We at Essex Court Chambers provide a substantial pupillage award of £65,000, and we give a guaranteed minimum to our new tenants of £100,000 in their first year of practice. And I have to tell you that none of the new tenants, to my knowledge, have ever called on it because they've already always earned more than that. It is therefore important that you have a good academic record when you apply. Most of our applicants have first-class degrees and usually a postgraduate qualification or some other experience in the commercial world. So bear in mind that to get a place at a purely commercial set is a challenge, and your CV must match that challenge. The second is it is very important that you ensure that when you are doing your pupillage and thereafter, that you get good advocacy experience. These days, many cases are settled before they come to trial. It's enormous, the percentage, it's about 84%. And furthermore, starting out as a young tenant in commercial chambers, you may find yourself as part of a large legal team with one or more QCs and several juniors. And that means the opportunity for you to do your own advocacy and be responsible for your own cases are scarce. But worry not, there are other ways of obtaining that advocacy experience through pro bono work. And in that way, you will be able to do some public service and hone your skills and practices. And I'd like to talk to you about the what was called the Bar Pro Bono Unit, Advocate. You can sign up to help from your second month pupillage. You can pick cases which suit your practice areas or areas that you would like to develop. You will expand your network. You will meet solicitors, you will get exposure to the judiciary, and they will be very grateful, I can assure you, that somebody is prepared to help a litigant in person navigate their way through the court process. And also there are partnerships that they have with the employment law legal advice scheme for the appeal courts and the tribunals. The commercial court and the London Circuit Commercial Court both have their own pro bono scheme called CLIPS. And this year we have had 436 volunteers sign up to Advocate. So that is a way to ensure that you get your own cases, take responsibility for them, and hone your own advocacy. Thank you very much.
Thank you, Andrew, very much. I'd like now to introduce you to Paul Stanley, QC. Paul is a former ICCA governor and someone who's taken part, I think, in probably almost every single event we've ever hosted, from ethics to expert evidence. Paul.
Thanks, Linda. I'm going to take a slightly different line from one of the difficulties with commercial practice is that we say commercial practice if we know what it means, but actually it's not really obvious from outside what commercial practice involves. And people will sometimes say, well, what's a kind of typical day or a typical week like? And there isn't really a typical day or a typical week. But I thought if I just ran through what I've been doing this week, it would give you an idea of the sorts of things that commercial barristers are dealing with. And I'm doing that mostly so that you can see the kinds of intellectual challenges, the kinds of skills that you need, the kinds of things which you might find interesting, or for that matter, absolutely ghastly about commercial practice, because discovering that you don't want to go into a particular area of practice can sometimes be just as useful as discovering that you do. So this week, I've been in court more than I normally would be. I've been in court 3 days this week. And I think that one of the features of commercial practice is that for the most part, as Andrew said, we spend more of our time preparing, more of our time doing paperwork, more of our time advising and getting cases ready than you would if you were doing something like crime, where you would be probably, in normal circumstances at least, you didn't have COVID going on, you would be probably in court quite a lot of the time. So this week, 3 days in court, and that for me is a lot of days in court. There can certainly be weeks and sometimes months when I'm not in court at any time during that period, because I'm preparing for something big. Monday and Tuesday, I was dealing with a case which involved arbitration. So arbitration is a procedure by which people have their disputes resolved by private tribunals in private. They often consist of silks or retired judges, and in this case, the arbitration had involved some silks. And this was a slightly unusual application where we were going to court to challenge an arbitration award that we'd lost. I can't say very much about it because it's confidential, as quite a lot of the work that we do is confidential, but arbitration in particular is confidential. But I think I can say it didn't involve any English people at all. It was an entirely international law dispute. And once it got to the court, it was mostly about law. It was mostly about, in fact, arbitration law as a particular sort of subspecialism of commercial law. And we were really arguing about the powers of an arbitration tribunal, what an arbitration tribunal is supposed to do, how an arbitration tribunal is supposed to approach its decision. So there was 2 days in front of a High Court judge. Wednesday was a quiet day because I was preparing for Thursday, which I'll come to in a moment. I did do a couple of bits of insurance work, which is another big area of commercial practice, at least it is for me. I spend quite a lot of my time dealing with insurance cases. Most of those cases are about liability insurance. They mostly, for me, come out of disputes from America, where people have been held liable, drug companies, for example, have been held liable for personal injury damages. Or in this case, one of them was a dispute from, trying to remember where it was from. Yeah, it was from Luxembourg, in fact. It's about a French case coming out of Luxembourg about some investment management advice. And that was really about the English law of contract. That was really interpreting contracts. And I spend a lot of my time dealing with the interpretation of contracts. And I had another insurance case, which I'll mention because a bit later, which was actually comes out of an African minerals concession, which has been taken away by the government, and the insurance of that minerals concession. And then I was preparing. I was doing paperwork. So 2 advices and some paperwork. Thursday I was in court. I was arguing about what's called a conspiracy claim, but it's not really a conspiracy claim. It's a big bust-up between 2 Indian steel conglomerates about who is going to pay for a big arbitration award. It's a case which started out as a freezing injunction in the commercial court, and then a search order in the commercial court, and then another freezing injunction in the commercial court. And a lot of the work that we do is what we call interlocutory. It's work which is before trial. It's work about things like interim injunctions and that sort of thing, which means that it's very much about submissions advocacy. It's very much about paper evidence. It's not necessarily about witnesses. We'll come to witnesses later. And on this occasion, we were arguing, I think, 6 silks or 8 silks and about the same number or possibly rather more juniors, arguing in front of a High Court judge about a really totally dull topic, amendments to pleadings. But that's all about preparation for trial, and we will spend a lot of our time working on preparation for trial, and that was what I was doing on Thursday. And then on Friday, I was looking at a case which comes out of Eastern Europe. It's a big family dispute about assets. There's a huge commercial aspect to it. And that, which is, again, in a sense, typical of commercial law cases, at least the ones that I do, it has no English law content whatsoever. It happens to be likely to bounce into the Chancery Division for various reasons. But if you actually look at the underlying facts and at the underlying law, there's no English law involved at all. There may be some Russian law, there may be some French law, there may be some Swiss law, but there's certainly no English law. So we spend quite a lot of our time dealing with one of the themes you'll have seen is that the disputes are often international, but they're also not only international as far as the participants are concerned, they're quite often international as far as the law is concerned. And then I came back at the end of Friday to do some more preparation work on this case involving an African concession. And we were looking there at a very typical question about what documents should be disclosed in an arbitration, which is going to be held in February. So we're all hands on deck, really, to try and get ready quite a big claim between November and February, where we'll be, I think, 5 weeks in front of an arbitration tribunal. Now, that is a very mixed week. It's quite a busy week. And the things that you'll notice about it, I think, are there's a lot of law, there's a lot of quite complicated facts, and the skills which are involved are often about trying to extract something simple from those rather complicated facts. And there's a huge element of international involvement. Not a single one of those cases was just a case which involved only English parties and only English law. And I think that is very much, if I say that there isn't a typical week, but that is very much a typical week. It would be extremely surprising for me to do anything different. What I enjoy about it, I think what I most enjoy are two things. First is the grappling with these rather complicated sets of facts and trying to extract something from them which is decidable. Because if you just when you first look at it, it's chaos. And trying to start from that chaos and end up with something that you can work off is I think, the number one skill that I enjoy. And secondly, the need to deal with that in an area which is very often complex interaction of different areas of law. Very often a lot of work on evidence. Surprisingly, we may not be often in court, but when we are in court, it often really matters, and the preparation for that. And it's the combination of those things which I think is exciting about the particular field.
Thank you very much, Paul. I'm going to introduce you now to Richard Hoyle and Athena Marquides. They won't tell you this themselves, but Richard Hoyle is described as a promising and rising barrister whose grasp of the law is impressive. And Athena is described in the Legal 500 this year as very bright, extremely conscientious and hardworking. And she picks up issues and absorbs large volumes of information quickly and provides accurate, timely advice. So I'm delighted that they're both here. And I'm going to hand over to both of them now. Thank you.
Thank you very much, Linda. And thanks very much to Paul and to Andrew. We're indebted to you for that fantastic introduction to commercial law and practice. I think Richard and I are going to take things slightly differently to the previous two speakers. So we are similar levels of cool, but there are some quite striking differences in how our pupillages were structured in our early years of practice. So we thought it might be helpful for us to cover some of those key topics in a more conversational structure so that our delegates can compare the two. By way of brief introduction before we start, I'm at Crown Office Chambers and I have been for 6 years since completing my pupillage. Crown Office is a mixed set, so we have quite a few very different main areas of practice. So in addition to insurance, general commercial work and construction and arbitration, which are the areas in which I now specialise, Chambers also does things like criminal regulatory work, personal injury and product liability. As a pupil and as a new practitioner, you're encouraged to do everything that Chambers does. And most people typically start to specialise about 3 to 5 years in. So a bit like Andrew, I had a slightly more mixed start to my practice before moving more towards the purer commercial work that I now do. I'm now going to hand over to Richard for a brief introduction from him too.
Hi, I'm Rick Hoyle. I'm a junior barrister at Essex Court Chambers. You might be forgiven for looking at our panel and thinking this is slightly the Essex Court Chambers show, but there are plenty of other commercial chambers who do commercial work that are out there. I think the Commercial Bar Association has over 20 member sets who are doing commercial work of one kind or another. I guess my experiences are perhaps in a more narrow set of areas, more focused on than Athena's were in her early years. But as Paul and as Andrew have already said, within commercial law itself, there is a huge amount of variety. I think the common theme is that you're probably looking at a contractual transaction somewhere at the heart of things. It's probably going to be of high value, and then you'll be looking at that from different angles. So obviously, some of those contracts will be about moving goods to different places. Some of those contracts will be about putting financing in place in order to make that work. Other people will be insuring the business that's going on against certain risks. So they're all different parts of the commercial relationship. And as has been said, it centres on the fact that the City of London is at the heart of global commerce, and so you have all of these international cases which, as has been touched on, might be entirely unrelated to England and Wales, apart from the fact you've got a contract governed by English law, or there might be one party that is in England and Wales. But everything else about the case relates to a foreign law. And so our courts end up doing some quite unusual things. They might have a whole trial on a case governed by Russian law, just by the accident of where one of the banks happens to be located in London or something like that. Or you might have an entirely foreign set of proceedings. You might have two Indian parties, but they happen to have chosen English law to govern their contract. And so the range of it is really, really quite something. But perhaps we should turn to a bit of a comparison of what our respective pupillages look like, because that's where most of these attendees will be at least starting out. So.
Great. So, Rick, I wonder if you might like to go first, because am I right in thinking that your pupillage was entirely non-practicing?
Yeah. So for some commercial sets, pupillage is just an entire 12 months of non-practicing. So although it's divided into a first 6, which is non-practicing for everyone, in your second 6 months, you could be sent out to court. But our chambers doesn't do that. We have a system whereby you spend about 3 months with an initial supervisor, and then you get rotated through various supervisors for about 2 to 3 weeks, so that you can experience some of the variety of commercial law that we've got on offer. So you might do employment law with someone like Andrew for 3 weeks. You might then do insurance with someone like Paul for another 3 weeks. And then those people at the end form the tenancy committee that decides whether your work is good enough or not, and that determines whether you're then offered a tenancy to join chambers. But I guess yours was probably a little bit different to that.
Mine was, because I think my pupillage was divided into 3 main seats, each of which you spend with a different pupil supervisor from a different practice area. But I think the more fundamental difference was that my pupillage was also split into a non-practicing first 6 and then a practicing second 6. And for anybody who doesn't yet know about pupillage in any detail, during a sort of non-practicing, either part or entirety of your pupillage, you typically share the room with the member of chambers who is designated as your supervisor. They may give you copies of their papers to work on, they may give you discrete topics to research, so you can get a flavour of the sort of work that they're doing, but also so you're really living and breathing the day-to-day of what it's like to be a barrister in that practice area. My practicing second 6 was very different, and it was a real step up, because in addition to shadowing and assisting my supervisors, I also had my own cases, an entire own caseload for the first time. This was predominantly small claims or other very low value matters, typically road traffic accidents. But it did mean that I had my very own clients, cases on which I was, not to sound too glamorous about it, but sole counsel. So I was drafting pleadings, attending interlocutory and final hearings in my own right, without any kind of supervision. And that is obviously significantly different to shadowing somebody and being able to benefit from their experience and oversight throughout the process. Now, in addition to the practicing and non-practicing halves of the pupillage, like Rick's chambers, my chambers also has written exercises, and we have 4 advocacy exercises as well, which are dotted around the pupillage year. And I was also routinely requested to assist other members of chambers, which was a great way to get to know them, to see other practice areas, and ideally to win supporters for the final tenancy decision. So it was an intense period, but really, really interesting. And I think one of the things that you really want to think about when you are applying for pupillage is what you're hoping to get from that experience, whether you are the sort of person who wants to be on your feet as soon as possible, or whether you're somebody who would benefit from, or would prefer to work as part of a team, to work on bigger cases. And we'll talk a bit more, I think, shortly about the differences between the kinds of cases that you might do in either environment.
So, I mean, Athena, you were then on your feet immediately in the second six. So how did your practice in your early years kind of differ from that? It sounds like you've developed in a much more commercial way than you started out. Absolutely.
I mean, it may sound trite, but actually the main difference from sort of the end of pupillage and the start of tenancy is you no longer have a supervisor. And as I say, it may sound trite, but there is suddenly a vacuum in oversight. There is no one checking in on you with any kind of regularity. There is nobody saying, now give me your pleadings, let me have a look at them. There's nobody coming with you to court. And that can be quite an alien experience for people, particularly if they've either been employed somewhere with a formal hierarchical structure with line managers and people that you report to, or if they have sort of school type experiences where, again, you have people requesting your work and checking in on you. And of course, you can always ask senior people for help. And I think Rick and I are both very lucky that we're at very nice chambers with lots of friendly and helpful people in them. But unless you're being led on something, there's nobody else who's really invested in your case in the way that you are. Now, solicitors are sometimes able and willing to discuss those cases. And on the bigger cases, you may have a team of solicitors who are very heavily involved and want to have that back and forth. But if you are doing the sorts of very small cases that I was doing in the early years, the road traffic accidents and things like that, your instructing solicitor will very often be the lowest level fee earner within the firm. And that will be somebody who just wants you to go and get the job done and isn't going to supervise you and isn't going to have that kind of input into your work. So if you're a junior barrister working unled, you will face a lot of responsibility very early on. And for some people, that is a huge part of the attraction. But if that doesn't sound very appealing to you, then you may prefer life at a set where you have much more lead work. Now, in terms of the work itself, Rick, you asked me how I moved across from sort of the RTAs to the more commercial work. It's an interesting thing. I think my insurance practice really only took off after I went and did a secondment at an insurance firm. And that involved quite a lot of active management from me. Very early on when I started out, I'd been caught 3 to 5 days a week. And the clerks can fill up your diary at a set like mine very, very quickly. You don't really get a say in the sorts of cases you're doing very early on. You just do what you're told and you go and get it done. If you do want to be doing something different, it's worth thinking about what you want to be doing and how you can try and be doing that sort of work. It's worth cultivating those clients. It's worth speaking to more senior people about the pathways that they followed to try and achieve the practices that they have and trying to line up those experiences and opportunities for yourself. Now, Rick, I think you're very fortunate. You've had some very exciting work, high-end commercial work very early on. I wonder if you could tell us a bit more then about the difference between your pupillage and your early years of practice too.
Yeah, and I think it ties into one of the questions that we've had in on the sidebar, which is about if advocacy wasn't really part of my pupillage, how did you go on then to be able to get your advocacy experience? And I suppose I should point out we also had internal advocacy exercises as part of pupillage, but it wasn't live in the sense of being in front of a court, although it was live in the sense of being in front of people like, I think I probably was in front of both Paul and Andrew, kind of passing critical comment on my advocacy skills, which is a thoroughly terrifying experience. I mean, moving into practice, then our clerks are obviously trying to get us out into the county courts as well around the country on small matters, and in terms of getting you the opportunity to be an advocate and to learn that. But the counterpoint is, as Andrew pointed out, there is a lot of lead work in chambers like ours. And so you will join a case that might have 3 or 4 barristers on that case as the most junior member of the team, and that will involve a lot of kind of research notes, preparing chronologies, helping with first drafts of skeleton arguments, things like that. But of course, because those cases are so big and valuable, you've got an immediate window onto some of the best QCs at the commercial bar arguing these cases. So some of the advocacy experience has to be about learning through osmosis, watching other people do it and thinking what works for them and what might work for you. And part of that's finding your own voice as an advocate, because just copying other people and students sometimes say, oh, do I have to be a certain way? Don't barristers talk in certain ways? Well, the most important thing is finding a kind of authentic voice for yourself. Because if you just copy other people, it will sound wrong because you're not that person. But you can pick up good tips from other people and kind of build them into your own practice. I'm conscious we've been speaking for quite a long time and Andrew and Paul haven't, so I wonder whether we want to give them the opportunity to dive in on any of the questions that might have come in.
Could I just go to one of them, which is, Daisy May, is it only possible to volunteer for advocate and clips once you have commenced pupillage? The answer to that question is yes. You have to be in your second 6 months. However, there is another organisation that I would refer you to, which is the Free Representation Unit. And that you can actually start when you are at university. So you can volunteer for FRU once you have done their training. And they appear in social security and employment tribunals throughout the country. If you go on their website, they will set out what the criteria are that you have to meet, and the training that you have to go through before you start taking your own cases. I commend you that organisation, because it is clear that if you've got some advocacy experience, that will enhance your CV. It will show that you are taking seriously the challenges that you are facing, and it will be something that you will no doubt be able to expand on in the interview with experience of cases that you have done when you apply for a pupillage. So if you want to start doing some advocacy before you begin a pupillage, then FRU is the place that you want to go. Could I also take one other question, and then I'll hand over to Paul? One point was made about the cost of doing a postgraduate degree, and to what extent, I'm just trying to find it on my, it's from Soraya Hamidi, and what she says is the commercial bar is often criticised for its lack of diversity and inclusion. How are you tackling this issue? For example, a postgraduate degree costs a lot of money, which means that some students may not be able to strengthen their application for a commercial pupillage. Well, the first thing I would say is that if you look at our list of members of chambers, I think it is fair to say that over the past few years, we have really increased the number of students who've applied to us and become pupils, then tenants, from diverse backgrounds. And a concerted effort has been taken by the commercial bar to increase diversity of candidates that apply for pupillages. Middle Temple has founded something called the Access to the Bar Scheme, which is a series of awards from people from non-traditional backgrounds who can apply and are funded for marshalling with a judge and sitting with a QC. We at Essex Court Chambers will permit somebody who is successful in a pupillage application to draw down up to £20,000 for their BPTC course, or to fund a postgraduate degree. So there are ways in which there can be funds given to you before you begin your pupillage to enable you to start a postgraduate course. Those are two that immediately come to my mind. Paul, do you have any other points that you would draw attention to?
Not on that, actually, no. Except to say, I don't think anyone should assume that a postgraduate degree is an essential for the commercial bar. I mean, quite a few people at the commercial bar do have master's degrees. Bear in mind that obviously master's degrees now can sometimes be done in conjunction with your bar training, which can be a kind of cost-effective way of doing things. But I don't think anyone should assume that that's required. The fact that quite a few of us do may just reflect the slight tendency of law nerds to graduate towards the commercial bar, but it's by no means an essential qualification.
Richard and Athena, there are a couple of questions for you specifically. I'm treading on Kevin's toes here, but Richard, there was a question from Cameron Safdar. If advocacy isn't part of pupillage,
I think that's the one that I picked up on just towards the end there.
Okay, thank you. And there's one for you, Athena. Can you see that?
Lindsay, can I just say something about that one as well?
Of course.
Don't forget that advocacy at the commercial bar is often written advocacy. In other words, oral advocacy is absolutely important, and I'm not saying the commercial bar doesn't do it. But in commercial practice, written advocacy is a very important part of the advocacy that we do day to day in courts. And in relation to that, I think you'd find that people at RSET, for example, were very heavily involved in doing quite a lot of work on written advocacy from a very early stage. So one has got to remember that advocacy is not just being on one's feet in court, although absolutely that's a very important part of it. It's also the whole process, which crucially at the commercial bar includes things like skeleton arguments and written cases.
Richard, you were telling me only yesterday that you're starting a very long trial in January with skeleton arguments due in by in the new year, with skeleton arguments due in January. That's a huge part of that case that you're involved in, isn't it?
Yeah, so I mean, tying in with what Paul has just said, this is a case that's set down for a 10-week trial at the start of January. It has pleadings or statements of case that are many hundreds of pages long. I mean, one of the things that I found immediately very intimidating, but you get used to it, is on the bar course, you will learn how to, because I don't know whether our audience, some of them are at university, some of them may be on the thinking about the bar course and have looked into it, but you'll learn things about drafting court documents. So setting out the claims, setting out the defense in response to that. And the practice that you will do on those kind of things will be small cases. You'll be creating a 5 to 10 page document. These cases, in commercial cases, sometimes we're talking hundreds of pages of these documents. And so having practiced this skill on the bar course with a kind of 5-pager, the first thing that my pupil supervisor said was, right, we're doing a pleading on this case, I'm going to do it, but you do a draft. Here are 3 lever arch files, can you go please? And suddenly I was like, that's quite different to my 3 pages of instructions from the bar course. But that's one of those things that seems immediately intimidating, but once you've had a couple of weeks of doing it, then you get to grips with it. So for me, I look sideways at some of my criminal colleagues who are in court every day of the week preparing multiple cases, and it terrifies me, the idea that someone would say, here, on a Friday evening, here are 3 cases and you'll be doing all of them on Monday morning. Whereas presumably if you said to them, could you write me a 70-page document, they'd think that sounds like quite an intimidating task. So a lot of it depends on your pupillage experience. But as Paul says, written advocacy is really important. Opening and closing skeleton arguments in huge trials can be hundreds of pages. And that sounds very long, but you're trying to communicate really complex things as simply as possible. So you don't want a longer document than is necessary. You're trying to really boil it down into the essentials that you need to make a persuasive case.
Could I take a question that was raised by our side, Ali Khan? How would you advise a second-year law student to improve his or her chances of succeeding at the bar? The first thing I would say is that you should join a mooting organization within your law faculty. Most university courses have some form of mooting as a component part of their course now, but I would certainly encourage you to improve your public speaking, both in mooting and in debating within societies at university. I would also advise you to join a law clinic if your university has one, or to volunteer to work at a citizens advice bureau or the like, because again, that will give you insight into advising people on actual cases, and it will impress people that you are following up areas of skill sets that are needed to be a successful barrister. As Derek Wood said in his introduction, apply for mini pupillages in a variety of different practice areas so that you can get some idea of what that work is like and whether you like it or not. And the more you do in different areas, the better it will be for you to see where your real interest lies. Because frankly, when you're at university, you have no idea of what proper practice areas are. As Derek says, and property law is, I found, deadly dull. And I have to say, I'm not sure that I'd run to do it in practice. But it's obviously something that it delights him in a way that it hadn't delighted him at university. I must say, I was always very keen on employment law. And that was, I never did any mini pupillages because at the time that I was applying to be a pupil, they didn't really exist. It was something that has come in more recently. By more recently, I say in the last 20 years. But it's certainly something that you should do. So mini pupillages, mooting, debating, and joining a law clinic or CAB. Those are the tips that I will give you.
Linda, I wonder if we might go back to the question from Cameron Safdar as well, who asked, how do you determine on application whether a set of chambers offers more led or independent work? And my answer to this is it's vitally important to just research, and you can do the sort of in-depth research which will yield these answers. For example, if you actually have a look at the profiles of individual barristers, particularly at the junior end, you can typically see whether they'll say, I've been involved in this big case, in brackets, led by so-and-so, or whether I've been involved in this case, in brackets, sole counsel. Another really good indicator is whether they do offer practicing or non-practicing second sixes. In general terms, if they offer a practicing second six, you are highly likely to be on your feet pretty early on into tenancy, if not immediately. So those are my sort of two big tips on that. But I think also it goes back to what Paul said. There are certain types of work which necessarily involve more oral advocacy and certain types of work which necessarily involve more written advocacy. And I think one of the fantastic things about the sort of work that certainly Rick got to do from a very early stage is that he'll have done more written advocacy, but these are really exciting, really interesting cases. And if you're the sort of person who really likes knotty points of law and getting stuck into something and trying to make a persuasive, coherent argument out of perhaps a rather chaotic looking set of facts or a not entirely coherent set of legal principles, you're going to love it.
Just to follow up briefly on the second year law student, what should I do point. Although obviously we're talking here about ICCA and about the future bar course, you don't have to decide that you're going to the barrister route immediately, and indeed thinking carefully about whether it's for you is important. And so I would say that you can equally go and do vacation schemes in law firms to see what it's like. I did that, went into a couple of litigation departments, and I didn't really like it. In some ways I felt that they were handing over the juicy stuff to the barristers just when it got interesting, and that I wanted to be the one, who was really taking that forward at trial. But it also ties into some of the diversity points, which is that all of the vacation schemes tend to be fairly well paid. And so actually I used at least one of my vacation schemes to save some money to fund myself being in London overnight to do a mini pupillage, because I wasn't living in London, and that was a way to help me cover the costs. So that's something you could think of from that angle as well.
Thank you, Rick. I'm just going through the question.
I've got one for the panel in general that came in and might have got a little bit lost. Can you recommend, or are there any resources or additional reading material to gain a deeper understanding of commercial law, either sort of more widely and more generally, or specific areas within a commercial practice?
Paul, do you want to deal with that?
That's quite a difficult question because there's so much that is covered by commercial law. So I think partly it depends on obviously the particular area you're interested in. Obviously, if you're interested in arbitration, for example, or conflicts of laws, private international law, there are specific bits of reading to do that you could do on that. I think I would say that's probably not particularly worthwhile for you to do. I don't think any set of commercial law chambers is ever going to be looking for someone to come to them as an expert in some particularly niche area of legal practice. I think it's really much more important to focus on your general legal skills in terms of your own experience. If you want to get a sense of what the commercial court does, or what the commercial court and the Chancery Division, which are probably the two areas where things are most done, actually, if you just follow cases in law reports, if you just take occasionally the most recent edition of the weekly law reports and see if it's got a commercial case, you'll pretty quickly get an idea of what those cases are about. But I don't think, probably at the stage that you're thinking about, are you interested in it, I don't think you're going to find that knocking yourself out on some really pretty dull textbooks is a particularly useful way to spend your time.
And I wonder, just to add to that, I mean, something that you may usefully want to do if you're interested in going into commercial practice is to try and improve your general commercial awareness. So, for example, I find that reading the FT is a really good way to keep up to speed with developments in what might be termed the commercial world.
Interrupt and just tell everybody that we've got 3 minutes left, and that if anybody wants to head over to networking for a one-to-one with one of the ICCA tutors, please do. And that at 11:50, if you refresh your browser, you'll see all the new sessions that are available. So before we run out of time, and there is a little bit of time left to deal with some other questions, I just wanted to thank all of you for being here and for sharing your wisdom and expertise. Kevin, is there anything pressing that we've missed that you can see in our chat?
I think just one. Andrew, right at the very outset, you said that most of the people in your chambers had first-class degrees, and I think that might have set at least one person's cat among the pigeons. And so a question's been asked: is the opportunity to pursue the commercial bar stifled by a high 2-1 degree?
No.
By stifled, I take it to mean completely closed.
No, not at all. But I think one has to be realistic and realise that you're going to have to bring other skills to the table, because you will be competing against people who have a first. I mean, can I be plain? I had a 2-1. I didn't have a first. And also, in answer to Sunil Ramati, I went to Bristol and the London School of Economics, so I didn't go to Oxbridge. One of our former members of Chambers, Lady Justice Andrews, went to London University. Claire Blanchard, QC, I think went to Liverpool Polytechnic. So don't think that just because you haven't got an Oxbridge degree or that you haven't got a postgraduate degree, that it's a closed chapter. But just realise that there are a number of commercial sets that are comparatively small, and therefore you will be up against strong competition. And that is why enhancing your CV with doing things like mooting and attending law clinics and having responsibility for your own cases through FRU is a good way to make a strong impression. And you've just got to think about what you can do. And one of the next sessions that's coming up is how to succeed in making pupillage applications. And I commend that to you. So no, it's not closed. Of course it's not. But you've got to be realistic and recognise that you will be competing against people who will have firsts. And you've got to ask yourself, how am I going to make myself such that I will be preferred over them?
Thank you all very much. And just a reminder that every session will be recorded and made available. Thanks again, everybody.
Thank you, Linda. Bye-bye.
Thank you.
Bye.
Thanks very much.